Good morning, Mr. Shedd.
Good morning. Dennis Shedd for Willie Furr. 14-year-old Willie Furr pled to carjacking, armed robbery, kidnapping, and assault and battery with a dangerous weapon. At his plea hearing, neither the judge nor his attorney went over the elements of the crimes, and the judge never asked him whether he was pleading voluntarily.
Did the district attorney give a statement of facts in the case?
There was a statement of fact, yes, Your Honor.
And did the statement of facts describe what happened?
Yes, it did, Your Honor.
It included a description of a rifle or a sawed-off rifle being held to someone, and they robbed him, and the defendant jumped in the driver's seat, and they drove off, and all of that was described?
That's right.
And then they went to the ATM and took the money from the ATM, and the defendant shared or took all of the money?
The defendant was in the driver's seat of the car. There were two other people
Right.
with the weapons in the back seat. The two people with the weapons went with the victim to the ATM machine.
And the victim was in the car while the defendant was driving?
That's right.
And you have a question about intent?
That's right. That's right.
And the other incident was also described, right?
There was another incident described, yes. That's right.
And the description included your client drove the car in and crashed?
Yes, that's right.
Okay.
That's right.
And then ran. Did he run from the car?
Excuse me, I didn't hear that.
Did he run, I'm sorry, did he run from the car
He ran
once
from
it
the
crashed?
car, yes, he did.
So he abandoned the car,
He abandoned the car.
and that was part of the statement.
That's right. That's all part of it. Now, it's certainly true. I'm not disputing the fact that there's a factual basis for the charges here, but the question is whether the facts necessarily establish the intent elements of the crimes. And in Henderson, the Supreme Court held that in a case like this, where the elements aren't set forth on the record and the judge doesn't ask if counsel has explained the elements, the plea is invalid unless the facts of the case necessarily establish the elements of the crimes. Now, the Commonwealth has taken the position that there's essentially no difference between the factual basis and showing understanding. Essentially what they say is that so long as the elements could be inferred from the facts, that's enough. And that's essentially the same sufficiency of the evidence test which is used to determine whether there's a factual basis for a charge or on a motion for a required finding. But in Henderson...
But these facts, it seems to me, the element you're contesting is intent, and where your client drove the car with guns to the heads of the victims or the bodies of the victims and then shared in the money. I don't see how you can question that his intent is at issue.
Well, I want to be, for one example, for the carjacking, to show a carjacking, there has to be showing that the defendant intended to permanently deprive the victim of his car. And the facts of this case, that's certainly not necessarily established. A jury could certainly come back and say, we only believe that he intended to use that car temporarily.
Or that he doesn't care of what happened, or that he does not care what happens to it. And he drove off in that car afterwards and crashed it and left it.
Again, I'm not disputing that a jury could find that he intended to permanently deprive, but that finding is not necessarily required on these facts. A jury could certainly find that all he intended to do was drive the victim to the bank initially, and then once the police came, he was trying to escape. Didn't want to keep the car. He had no intention of keeping the car. He was just trying to get away from the police at that point who came on the scene. So those facts do not necessarily establish that he intended to keep that car, which is the element of the crime of carjacking.
So is your argument that the statement of facts has to be sufficient to carry a conviction, not just enough to warrant the case getting to the jury?
Absolutely it does, yes.
It has to be enough to carry a conviction.
If the purpose, I'm not saying to show a factual basis for the charge, all that has to be done is present enough evidence to get to the jury. But when you're relying on the statement of fact, not only for that purpose, but also to show that the defendant understands the charges, yes, there is a higher standard here. And Henderson established that. Because in Henderson, the court assumed that the state's evidence was so overwhelming that a jury would have almost certainly convicted the defendant and found the necessary intent. Nevertheless, the Supreme Court held that the motion for required finding should have been allowed in that case because a jury would not have been required to draw that inference. And therefore, the court said the defendant's admission to the facts did not necessarily establish his guilt. Under Henderson, the facts...
In Henderson, there was not a written waiver, was there?
Was there a written waiver in Henderson saying, my lawyers explained to me the elements of the...
If there was, it's not mentioned in the facts,
I didn't think so.
no. But,
Mr. Shedd, let me
Yes.
ask you this question. With respect to the ruling of the appeals court, I mean, I recognize you're looking at the underlying thing, but what is the aspect of the appeals court's decision with which you take issue?
again, I believe the appeals court, the cases cited by the appeals court are pretty much all cases addressing the factual basis of the charge, whether there's
Sufficiency of the
sufficient
evidence.
evidence.
Correct.
So my position there is essentially the appeals court applied the wrong standard.
So
They
if we-
applied sufficiency of the evidence to show that the defendant understood the charges, and under Henderson, that's the improper standard.
So I take it that if we were to clarify the statement, I mean, the standard, which is to say that if the sufficiency of the evidence is not sufficient, what's really going on here is a joint venture, right? Whether he understood all the complexity, whether this 14-year-old understood all of the complexities of joint venture, correct? That if you are in the car, you'll be liable for whatever else happens, correct?
That's that, and also with the carjacking, that there's insufficient proof that anyone intended to steal the car as opposed to use it temporarily. That's right.
Well, okay, but if the judge had said to the attorney here, have you discussed with your client the elements of the charges he's about to plead guilty to? Is it your view that that would have been sufficient?
Right. That's
Okay.
right. But that never happened here.
Right. Well, he signed a waiver to that effect.
Yes.
Now,
but
that
this-
can't substitute completely, but it certainly says something, doesn't it?
Yes, but I think this court has consistently held that a signature on a form is not an adequate substitute for a colloquy on the record, and that's because
Not an
people-
adequate substitute for a colloquy. There is a colloquy here. I mean, there's a lengthy description of the facts, and you're saying, well, maybe not quite enough so that he understood what all the elements were of each and every offense. So you have a full statement of facts, which is clearly sufficient to convict,
Right.
plus a signature saying, yeah, you know, I've discussed the elements of the charge with my lawyer. Doesn't it have, so you're saying the written waiver has no bearing at all on anything?
Well, I think it's frequently the case, like it or not, that people sign written forms without reading them.
The lawyer
And-
signed it, your client signed it, the client's, well, we'll say guardian signed it, the judge signed it. I mean, but
Do
you're
we-
saying
do we
it's
know
of
why
no
this-
significance.
It's not enough, no. It's
Not enough, but you're saying it's of no significance.
If there had been some other indication on the record, some sort of indication
But
from
isn't the
defense
other
counsel, there'd been some
indication the
discussion,
facts?
that might be something.
But isn't the other indication the statement of facts?
Right.
No. The
Mr.
statement
Shedd,
of facts doesn't reach it in this case. Because, I mean, I'm just looking at Henderson, and if you just take this as a matter of simple logic, if nobody says on the record that they've explained the elements, the judge doesn't ask counsel if he's ever explained the elements of the crimes, then if from the facts you could draw an inference negating one of the elements of the crime, then the judge can't be sure that the defendant actually understands the charge he's pleading to, because that negative inference could be what is in effect the defendant's state of mind about this incident. Only if the statement of facts is such that you could not draw an inference negating an element can a judge be certain that the defendant understands the crime.
How
that-
can you
that he's
negate
pleading out
the
to.
element, though, that he permanently intended? It isn't only permanently intended to deprive the proper owner of possession. Our cases have interpreted it as also not caring about what happens to the item.
I
And how can
disagree
you-
with that, Your Honor.
There's a
What
case
the
that
courts have
states
said is that if there's evidence that the person is indifferent as to what
That-
happens,
yeah, right.
from that a jury could infer that he intended it to deprive the person permanently. But that's
Well, if he
that.
drives the car and crashes it and leaves it, what conclusion is there other than that he was indifferent to what happened to the car?
I agree with that, and that's why I'm saying a jury could infer that he intended to permanently deprive. That's not required. Indifference as to what happens is not the same as intent to permanently deprive. The court has said if there is evidence of indifference as to what happens, you could infer intent to permanently deprive.
Right.
But it's intent to permanently deprive that is the element, and you're not required to draw that inference.
Don't the cases, that they don't say indifference to what happens, but indifference to whether the owner recovers possession.
Right.
and go
Isn't
on
that
to say
different?
may be found to intend. That's your point, right?
Right. From that, you could infer, but that inference is not one that's necessary to be drawn. That inference is not transformed into an element of the crime. That inference is one way in which you can get at the element if the jury goes along with that inference, but they're not required to draw that inference. And that's just the point in this case, is that I'm not disputing, again, that a jury could infer that he intended to permanently deprive, but it wasn't a necessary finding in this case. And similarly with the other crimes, a jury could infer that he shared the intent necessary for a joint venture for the other crimes, but that was not a finding that was necessarily required on the facts of this case. And under Henderson, that's the showing that has to be made, is that this person has to understand the charges, which means those facts have to necessarily establish the elements of the crimes if there's no other putting on the record that anybody's ever explained the elements to the defendant.
If we assume that this 14-year-old did not understand all the elements of the crime, especially as to carjacking, is there not any harmless error standard that we should apply?
I think the cases are pretty clear that when there's an inadequate showing of voluntariness on the record, I think Boykin and other cases subsequently in this court, Fernandez and others, say that if there's no showing of voluntariness on the record, then a motion to withdraw a plea has to be allowed. And that's also somewhat related to one of the issues the Commonwealth raised, sort of suggested that if there isn't a showing of voluntariness on the record, the judge still had some discretion to deny a motion to withdraw a plea due to prejudice to the Commonwealth. And I think Nikas pretty flatly contradicts that. In that case, the court discussed prejudice to the Commonwealth and basically said, if there is no evidence of voluntariness on the record, the motion to withdraw the plea has to be the in that case.
What do you mean by voluntariness? I mean, in this particular
Well, this
instance,
is it.
he got a terrific deal.
If there's a record as to whether the plea is voluntary and intelligent, if the record doesn't show that, then the motion to withdraw the plea has to be allowed.
So are you saying then that we should consider this failure to make sure that he understood the elements as part of the totality of circumstances and evaluating its voluntariness? Is that what you're saying?
I'm sorry, I didn't catch all
Are you
of
saying that if we were to find that the record is not sufficiently clear that he understood all the elements, that we should then take that finding as part of the totality of circumstances and view it in the context of whether or not the plea itself was voluntary?
No,
or are
I'm
you
sorry,
saying it's a per se error and requires that the plea be vacated?
No, I think that it's not a totality of the circumstances. In the Henderson, I think, requires that if there's no showing on the record of an understanding of the charge, then the motion to withdraw the plea has to be allowed in that case.
How are you
that's the
saying that
circumstance here.
what is the problem with the facts in the second case as to what was A and B DW and whatever else it was?
Well, the second
He
case
walked,
isn't
he
an
walked up
issue
with
here.
his companions to a man and a woman. One of the companions put a sawed-off rifle to the man while the defendant searched the man in his bag, and the other two searched the woman. Now, how can there be... You don't need joint venture there. The defendant is the principal.
That's not an issue in the case.
Well, you
The
say-
second incident is not an issue in this case,
You
only
say-
the first incident.
Oh, you're not contesting the second
No,
incident?
I've never raised any, I mean,
Well,
the
that
only
wasn't clear
case
to
on
me,
issue
but
is the
okay.
September 13th issue, the first of the two incidents.
No.
There was never any motion, I was never appointed to represent him on the other case. There's no issue there.
If we concluded that there was insufficient information on the record to conclude voluntariness, knowing intelligent voluntariness, with respect to the larceny of the carjacking, but there surely was with respect to the other charges, does that make a difference here? Does that affect the armed career criminal issue, which is really at stake?
If there were enough for the other crimes,
If we said there was insufficient for carjacking,
Right.
perhaps we will order a new trial on that, but the others will remain. Does that have any impact on the outcome of your client's situation?
yeah, certainly it would, because one of the, for the armed career criminal statute, I think it has to be a previous crime of violence. I think the armed robbery, for example, would certainly qualify as a prior
And-
crime
and-
of violence if
and
that's
can
stuck
we
in the
take into
carjacking dropped out.
Can we
Okay,
take
so it
it-
wouldn't make a difference.
In that case, yeah, it would have no effect. If that were the court's result, then that would have no effect on the client's current position. That
Okay.
armed career criminal would still be there.
And
Okay,
Are
okay.
we permitted, in your view, is it of any relevance to our consideration that your client didn't contest the voluntariness of the plea until he was subject to this armed career criminal penalty?
No, I don't believe it's relevant. A motion to withdraw a plea can be brought at any time, and I think his motivation for, for bringing the motion has no effect on whether the plea was itself voluntary and intelligent, and whether the record establishes that.
And are we to take into consideration at all the judge's statement, and the judge was an experienced judge, I believe, who said, and because this has to do with whether the plea is voluntary, because the defendant was getting a very good deal. The judge says, I have to admit, quite frankly, this is a horrendous set of facts that I've seen. I know of his young age, but good Lord, this is a bad set of facts. And I was surprised at the reasonableness of the recommendation of the Commonwealth. Now, doesn't that have some bearing on the voluntariness, that this was a really bad set of facts, and yet he was getting a very good deal?
It certainly might suggest, it could something you could take into account on the voluntariness. It has nothing to do with whether he understands the charges, though, certainly.
No, but you have other claims.
And there's still, aside from that, the judge never asked him any questions that gave him any opportunity to discuss the issue of voluntariness on the record. Just as a second point that I've raised, that the record doesn't adequately show it's voluntary. There were never any questions about that. But whether it was a good deal, a bad deal, has nothing to do with whether he understood the elements of the crimes.
Well, with respect, let's assume, can't the judge discount your client's affidavit in this case? It's an affidavit, right?
Yes,
saying he
it
was
is.
coerced?
It is.
Okay. Can't he literally discount it completely because it's 8.5 years afterwards and only prompted because of subsequent different criminal proceedings? And if the judge discounts that and says there's no credibility to this, do you still say that the colloquy was so inadequate on the subject now of coercion or
Voluntariness and
non-coercion
coercion.
that it has to be set aside?
Yes. And I think in Fernandez, it raised a similar situation. There was basically, in Fernandez, the court reversed the denial of a motion to withdraw a plea. And there, actually, Fernandez had more opportunity to raise the voluntariness issue than Furr did, because the judge, at least towards the end, asked an open-ended question. Do you have anything else to say? Here, the judge never asked anything that gave the defendant any opportunity to raise the voluntariness issue. And in Fernandez also, there was an affidavit from the defendant saying, I was coerced, my lawyer wasn't prepared and said this and that to me. And the court reversed the denial of the motion and noted that here's this affidavit. We're not saying the facts in the affidavit are true, but it sort of lends, there is some support for a coercion claim here. And the judge here was in the same position. This court's in the same position as the court was in Fernandez, I think.
We have cases that say where there is no record, there's no transcript, in effect, of what took place at the plea. There's a presumption of regularity about what occurred, and the burden is on the defendant to show what transpired at the plea. But where we have a transcript of the plea colloquy, where we have a complete record of what occurred, who has the burden of proving what?
Well, I'd say, ultimately it's the Commonwealth's burden to prove that the record establishes the plea was voluntary and intelligent. And if the Commonwealth doesn't meet that burden, then the motion to withdraw the plea ought to be allowed.
But don't we have cases that say that a motion to, post-conviction motions to withdraw pleas are treated as motions for a new trial? Motions for a new trial, the defendant has the burden. And numerous of our cases say that.
That's right.
So who has what burden?
There's certainly there's a lot of other cases saying when it comes to voluntariness of the plea, then the Commonwealth has the burden of showing that the plea was a voluntary and intelligent plea. But nevertheless, I'm still, presenting the position that the record in this case, if you look at the transcript, there's not a single question addressing the issue of voluntariness. There's nothing there. It doesn't exist. And I don't care which party has the burden. There's nothing in that record that addresses the issue or gave Mr. Furr any opportunity to raise the issue of voluntariness. The issue just never came up. The only time that voluntariness is mentioned is after the colloquy the judge did conduct. The judge then says, I find this was a voluntary plea.
Thank you, Mr. Shedd.
Thank you.
Good morning, Ms. Saxon.
Good morning, Your Honors. May it please the Court, Hella Saxa on behalf of the Commonwealth.
Who has what burden in this case?
The burden of voluntariness always remains on the Commonwealth, and the Court has said that in McGurk. Nonetheless, the defendant has to present a credible reason that outweighs the risk of prejudice to the Commonwealth. And in this case, the defendant has failed to do so. This is the latest attempt of the defendant to rid himself of the armed career criminal conviction. And he has, since 2001, represented by the same attorney, made multiple attempts on direct appeal through a federal habeas corpus petition and a motion to correct the sentence. And after all have failed, he filed a motion to withdraw the guilty plea to the underlying offenses.
And it seems to me that's a basis on which we can, or the trial court appropriately discounted, let's say, virtually everything the defendant said, but we're still left with a colloquy in which there's not a single mention, as best I can tell, of whether you're doing this voluntarily, or were you coerced in any way? Did anyone threaten you? I mean, there's none of that colloquy. None, is there?
The defendant had an opportunity to withdraw the plea. The judge offered him that after he had laid out the sentence he was facing, and he had asked him all the necessary questions to determine whether he entered into the plea voluntarily.
But he didn't ask all of the necessary questions.
Well, he asked him his age, his schooling.
No, I know, but we're missing how we deal with the missing of the critical part is a different issue, but you can't say that he asked all of the necessary questions.
Well, there are certain questions he did not ask, but the entirety of the record that this court should consider according to Colin Toney, and that includes the written waiver form. Looking at all that was before the judge, this was in fact a voluntary plea.
How do we deal with Fernandez and Fernandez's statements about the colloquy being inadequate because the defendant was never asked, essentially, whether he was doing this freely and with full understanding?
That's right.
Not
However,
as a result of threats.
In Fernandez, certain questions were not asked that were asked in this case, and those are whether the defendant was satisfied with his attorney, whether he was undergoing any psychiatric treatment, whether he suffered of mental illness, whether he was under the influence of drugs or alcohol. All these questions were asked in the present case, but they were not asked in Fernandez.
Okay.
Was the sentence, there were two robberies that were at issue that he was pleading to, correct?
That's correct, yes.
Was it concurrent sentences?
They were. On both sets of facts to which the defendant pled, the defendant was sentenced to DYS until age 21, and he received a 2-year suspended sentence on the assault and battery with a dangerous weapon. And the sentencing on the facts, the second set of facts that is not before this court, the sentencing on those occurred at a later point because apparently at the plea colloquy some paperwork was not in front of the judge. But the plea colloquy itself was with regard to both sets of facts.
But all the sentence has been served as to both sets of both crimes. Is that correct?
Yes.
But the defendant is contesting it, as the defense counsel just stated, because of the effect on the career criminal conviction.
That's
and he
correct.
said that even if we reverse one, let the other stand, there'll be a better effect on the career criminal because
all 4 offenses at issue here were served as predicate offenses for the
so
armed
if
career criminal
anyone gets
charge.
knocked out, it will no longer be a predicate offense. I mean, there won't be a sufficient predicate offense for the career criminal. That's what I understood
But
defense
there will,
counsel to say.
even if one is dropped, there still remains enough for the armed career criminal.
You only need one?
I believe so.
So it appears that since the time has been served, and it's as many years hence, that the only reason for contesting the voluntariness of the plea is because these convictions are now serving as predicate offenses.
That is correct. And that is also why he's, I assume, only contesting half of his guilty plea.
So does that then, does that have some impact on our deciding whether he did indeed enter these pleas voluntarily?
I believe so, because he does not raise a voluntariness argument with regard to the plea as to the other 4 charges, 2 charges of assault and battery with a dangerous weapon.
But I take it because the reason there is consistent, I take it, I don't know, that the reason there is consistent with Henderson. Namely, you don't have you don't have the little gap, as I think of it, where the jury could but need not infer. You actually have facts where the facts establish the elements.
I believe the facts in this case establish all of the
No, I
charges.
understand that, but I take it that that's the reason why the other, whichever ones are not contested, is because one couldn't make that claim plausibly.
I would respectfully disagree. I think it is simply because the defendant is attempting to rid himself of the armed career criminal charge, that the other convictions he has served those sentences,
Okay.
and they are no longer
Okay, so
But
they're
he
out of the
could-
picture
affecting
anyway.
him.
But he could make the same claim of lack of voluntariness and coercion, et cetera, as to the other charges.
Of course, it was the same plea colloquy.
Yeah, but the facts, and with respect to the other crimes, I take it, if the bare facts, on the face of the facts, if a jury found those facts to be true, they would have to find, at least morally, would have to find him guilty of the offense. On these facts, on the facts with respect to this particular charge, a jury could find all the facts to be true, but not necessarily make the inferences that are necessary to convict him of this particular charge. That's his argument.
I know it is, but I would strongly disagree. And this court in Commonwealth v. Colantoni, 396 Mass 672, has said that it is sufficient if the defendant admits to facts constituting the crime, even if he is unaware that the facts admitted are the elements of the crime.
No, I understand that, but that doesn't deal with the influence point. I mean, I saw your reliance on the case, and I looked at it. It doesn't deal with the influence point.
That's right. The point the defendant now raises was addressed to some extent in the dissent in Commonwealth v. Begin, 394 Mass 192, where the dissent, Justice O'Connor, said that the relevant question should be not whether malice in a second-degree murder case can be inferred from admitted facts, but whether malice is necessarily implied from facts and therefore admitted. And the majority of this court rejected that argument in Begin, and just 1 year later issued its holding in Colantoni, saying that the facts, if the facts would survive a directed verdict at a jury trial, they're sufficient as a basis for a guilty plea, even if the defendant is not aware that they constitute the elements of the crime. And in its interpretation of Henderson, this court has always said, since 1978 and the decision of McGurk, that there's three ways in which the facts can be proven, and that is, one, an explanation of the essential elements by the judge, and second, a representation that counsel has explained the elements, and third, defendant's statement admitting to facts constituting the unexplained elements. And the court has used this standard even last year in Commonwealth v. Sherman.
Would it be fair to say that a representation of that the elements have been explained to him has been established by the use of the form which the judge, the lawyer, and the defendant signed?
On its own, that would not be sufficient. But together with the oral colloquy, it certainly enhances the Commonwealth position that this was a valid waiver. And in Colon, this court has said in footnote 14 that a signature on a form is one of several facts that bespeak the defendant's intention to consummate the plea bargain. And therefore, the form should not be entirely disregarded. The facts, the cases that defendant cites, such as Commonwealth v. Jones, 60 Mass Appeals Court 88, in that case, the defendant had waived a recitation of the facts, so there was no recitation of the facts on the record at all, and the court rightly said that that is not sufficient, and the Commonwealth does not here take the position that there shouldn't be an oral colloquy.
So if a defendant is presented with a list of questions that constitute a perfect colloquy, and one of the questions is, have you been advised that you're giving up your right to remain silent if you plead guilty? And he writes in, yes. And have you been advised of the elements of the crime? And he writes in, yes. And so they have a colloquy, or he fills in the form, submits it to a judge, and the judge says to him, did you do it? Did you commit the crime? And the defendant says, yes. That's the only question the judge asks. That written colloquy is enough. The written form should be enough, coupled with the colloquy.
Rule 12 says that there has to be a colloquy in open court, and I believe asking one question would not satisfy that requirement.
Does it matter here that this was an admission to sufficient facts as opposed to a guilty plea?
No, it shouldn't.
Do you think it's the same?
With
it's a
regard
different
to the
question. The question for a guilty plea is, are you guilty of the crime? The question asked of this 14-year-old was, are you admitting to those facts today, which were the facts as stated by the ADA?
According to Colin Tony, that is sufficient.
Sufficient for a guilty
For a
finding
guilty
or
plea.
sufficient?
Yes.
And is it your view that there should be any, if we were to agree with Mr. Shedd, that we cannot be sure from this record that Mr. Furr understood that permanent denial of the vehicle was an element of carjacking, is there any harmless error that we should consider or not?
Well, this court is not required to consider a harmless error in that case because, according to Commonwealth v. Salerno, 356 Mass. 642, the taking of property without authority and uses, if a defendant uses it to show his indifference, whether the owner recovers possession, that is sufficient to show his intent.
No, it may be found. That's the whole point. You can't skip over the may be found of Salerno.
Yes. However, in Commonwealth v. Souza, a case that I
understand, but if
came-
you're going to use Salerno, it's a may. May, but not must.
That's right. In Souza, which I did not cite in my brief, but I'll be happy to submit a letter to the court, the Commonwealth had proved that the defendant intended to permanently deprive the Department of Public Works of a truck that was taken at gunpoint and used to effectuate escape. And the court said that it did not matter that the defendant was forced to abandon the stolen truck shortly afterwards.
Was Souza a jury finding?
It was, yeah.
Yeah, that's the point.
But,
Well, no, Your Honor, because the standard would be the same. If it survived, in Souza, it survived a directed verdict, and that
Yes,
would be
and
sufficient
in
for a guilty
Shedd's
plea.
point, I mean, the juvenile, Mr. Shedd's point is that the standards are different.
Yes, but my position is that they're not.
No, of course I understand your position.
well, let me rephrase. If we were to find that the evidence is sufficient with regard to the carjacking, all elements, but that we don't think the record is sufficient for us to be confident that this 14-year-old understood that the permanency was an element of the crime, what do we do?
You affirm the denial of his motion to withdraw the plea, because the record, as in its entirety, establishes that the defendant, or together with the case law, establishes that defendant does not have to know that the facts he admits to constitute the elements of the crime, and all the other requirements of the guilty plea were satisfied here.
Ms. Sachs, I understand his lawyer, his trial lawyer, the plea the lawyer at this hearing was disbarred.
That's correct.
Do we know why?
I don't. I'm
Okay,
sorry.
no, it's not in the record.
It's not in the record, no.
But we know he got a real good deal, don't we?
Yes, we do.
And the judge understood that he was giving this 14-year-older, that the Commonwealth was recommending and the judge was giving him a very good sentence.
That's right. The motion judge, or the plea judge, understood that very well.
And his two older brothers were there with him, and they signed off on everything.
They did. One signed the form, but both identified themselves in court. Unless the court has further questions, I would ask that you affirm the denial of the motion to withdraw the plea. Thank you very much.
Thank you, Ms. We'll take a short break.